Good evening, Mayor, members of the City Council, and members of the public. My name is Albert Ramirez. I am the Assistant Director for the Oxnard Housing Department. And I'm here presenting on behalf of Brenda Lopez, the current Interim Director for the Housing Department. The item before you today is the introduction of a tenant anti-harassment ordinance. Background: a minority of landlords are reported to employ coercive tactics in order to induce tenants to vacate their rent-stabilized units. Reported tactics include reducing housing services, issuing eviction notices based on false grounds, threatening to contact immigration authorities, or refusing to conduct repairs required by law, subsequently leading to tenants being forced to vacate through these tactics, oftentimes allowing landlords to raise rents to market rent without abiding by the 4% rate caps for applicable units or going through the city's fair petition process. Several jurisdictions such as Santa Monica, West Hollywood, Oakland, San Jose, and Los Angeles have seen similar trends resulting in the adoption of tenant anti-harassment ordinances. It is reported that these ordinances help serve as a deterrent to illegal conduct and assist tenants in their legal defense against landlords who engage in such harassment. In response to escalating reports of landlord harassment in Oxnard, staff was asked to bring forth a tenant anti-harassment ordinance for City Council's consideration. Housing staff engaged Stephen Lewis Esquire to prepare a tenant anti-harassment ordinance. Mr. Lewis is an attorney with nearly 30 years of experience related to rent stabilization and just cause evictions and tenant protection ordinances. When drafting the proposed ordinance, Mr. Lewis incorporated best practices from the various jurisdictions consulted, while also ensuring the ordinance did not violate any constitutional protections or published appellate opinions. The proposed ordinance prohibits harassment by residential landlords and identifies specific acts and omissions by landlords that constitute prohibited harassment. Violations under the ordinance is a misdemeanor and may be criminally prosecuted by the city. Based on the experience of other jurisdictions with similar ordinances, only the most egregious cases are prosecuted as violations of tenant anti-harassment laws. The ordinance also allows the aggrieved tenant, the city, or an organization to pursue civil action for damages and the recovery of attorney fees. The ordinance would apply citywide to all residential tenancies within the city. In preparation of implementing the proposed ordinance, staff reviewed over a dozen anti-harassment laws. All of the jurisdictions staff reviewed, except the city of Santa Monica, include anti-harassment laws in their rent stabilization or tenant protection ordinances. This approach has a drawback of limiting these protections to only rental units that are covered by those ordinances. Because of this limitation, and in consultation with Mr. Lewis, staff recommends a standalone anti-harassment ordinance similar to the city of Santa Monica, which covers all residential tenancies within the city. The city of Santa Monica's tenant harassment ordinance is administered by the city attorney's office, and specifically the Consumer Protections Unit. The Consumer Protection Unit engages in affirmative litigation and community education to enforce and promote consumer protections, including renters' rights, fair housing, and code enforcement. According to the city of Santa Monica's housing element, this ordinance would apply to 33,505 renters identified in their housing element. The unit is staffed by 5 lawyers, 2 investigators, and support staff. Their process includes receiving complaints online. Once received, having an investigator review the complaints, analyzing supporting documentation, interviewing involved parties, and sending any substantive complaints to the city attorney's office for review and prosecution. The city of Santa Monica receives approximately 200 complaints a year, and on average, 5 to 10 of those result in litigation. Each of those complaints warrants a thorough investigation, which often results in substantial staff time needed to prepare these cases prior to the city attorney's office receiving them. Additionally, tenants may also employ their own methods, which includes litigation and mediation through a private attorney to exercise their rights under the city's ordinance. However, many residents face financial constraints and are not able to utilize this method to address their violations. In those cases, the tenants will seek utilization of the city's anti-harassment ordinance program. Adoption of a tenant anti-harassment ordinance would be ineffective without adequate staffing and resources to enforce the ordinance. Staff estimates that approximately 22,327 housing units are subject to the ordinance. Adoption of the ordinance will result in an expansion of the number of types of complaints received, as well as in-person phone inquiries. To launch a comprehensive citywide program, the Housing Department requests authorization to hire 2 positions, one partially dedicated assistant city attorney and one fully dedicated housing investigator. The assistant city attorney will conduct legal research, prepare opinions and regulations, prosecute civil or criminal violations related to the tenant anti-harassment ordinance and other municipal codes, and represent the city in a variety of litigation. The housing investigator will investigate tenant complaints, conduct research, interview witnesses, prepare reports, and make referrals for criminal prosecution or civil litigation or to nonprofit organizations. An annual budget of approximately $505,000 is needed to support the two positions, including benefits and fixed charges. The recommendation before you is that the Community Services, Public Safety, Housing, and Development Committee review and recommend that the City Council approve the first reading by title only and waive further reading of the proposed ordinance title, Ordinance of the City of Oxnard, California, adding Article 3 to Chapter 27 of the Oxnard City Code establishing tenant anti-harassment protections, and review and authorize 2 full-time equivalent positions and the associated budget as part of the fiscal year 25-26 budget for implementation of the proposed ordinance. That concludes my presentation. Thank you.